Hey, thanks for joining us on Discover Southeast Texas. This video is part of our Elder Care series, and I am here today with Randy Drewett. He is a board-certified elder law attorney, and he's also board-certified in estate planning and probate law. Now, we could talk about many things in elder care, but today we're going to focus primarily on senior wills and paying for nursing home care. But first, can you just define what is elder care?
Well, elder law is dealing with the legal issues that are specifically geared toward the needs of seniors, because what seniors need in their planning is much different than what other people need. Their circumstances are different, their future is a little uncertain, and they need very specific planning to be able to have the flexibility to deal with things that are coming their way.
Okay, so senior wills is one of those things I know that you deal with, and it's a biggie. So can we talk a little bit about that? Tell us what is different between a senior will and just a regular will.
Well, generally when you're talking about a married couple, people have a tendency to believe they're obligated to leave all of their assets to each other when the first spouse dies. And that's not only not true, it's generally a bad idea. When you get to be a senior, the older you get, truly the less able you are to manage your own funds. So you may need assistance from a family member anyway, so why not leave the estate of the first spouse to die in a trust for the benefit of the surviving spouse? That allows the family member who will be assisting the survivor to have a better way of dealing with those assets.
Right. Well, and that's, I know, a very complicated thing to do, the estate planning. And so someone like yourself handles that all the time, right?
That's what we do.
That's your specialty.
That's what we do.
So, you know, part of senior will and estate planning would be to prepare for possibly paying for nursing home care, right?
That's correct. When you leave everything to a surviving spouse, what you're doing is you're taking the 50% that belongs to the first spouse to die, and you're giving it directly to the surviving spouse. That's doubling the size of their estate. So if the surviving spouse needs nursing care, they have to deal with 100% of the assets in order to be able to potentially qualify for Medicaid. Whereas if the first spouse leaves their estate in trust for the surviving spouse, the assets that go into that trust are not counted by Medicaid. So you can save 50% of the estate by having a proper will.
Okay, wow. And that makes me kind of think about just setting up power of attorney also. I guess that's very important.
Well, powers of attorney are probably the most important thing from a planning standpoint that we deal with, because people believe that a power of attorney is just a standard thing that you can get off the internet or get anywhere you go, and that's not true. A standard Texas format for power of attorney limits what the agent can do. And when you're dealing with trying to qualify for nursing care, you can't have those limits. So a regular power of attorney is just generally not going to work when you're planning for trying to qualify for Medicaid.
Wow. Well, I've learned so much today, and I know these guys have learned so much too. So how could someone get in touch with you if they need to talk to you about setting up their estate?
Well, we're here in Beaumont, and our number is 833-4000.
Okay, great. Well, thank you so much for joining us today, and thank you for joining us on Discover Southeast Texas, where I highlight area businesses, people, and events that make this community better than it already is.